performing on the Warner stage as the Wizard of Oz. He jokingly says he serves on the Warner Board of Directors only to get good roles on stage. On the judge's serious side, he is an internationally known children's rights advocate. His efforts that brought him to the Oval Office were honored by President Bush, and the Rose Gardens were won by President Clinton. He's appeared on 2020, Good Morning America, he's testified in Congress, and spoken in the UN General Assembly. But as he says, most importantly, he is a two-time All-Harris Fellow. Ladies and gentlemen, Judge Charles Gill.
Thank you for that kind introduction, and let me put it this way. The American Bar Association has a new project. It's called the LUB Project, the least understood branch of government, which is mine, judges. And we are misunderstood. I'm going to clarify that a bit today, all right? Now, the law and judges, therefore, touch every aspect of your lives. Everything that you're doing right now, the clothes you're wearing, where you work, where you live, what you drive in. We touch everything with the possible exception of individual thought. And even then, if you decide to express your thought, you might be sued if it's slanderous, right? So today what I want to do is try and demystify judges for you, okay? Give you a peek behind the road. All right, you're going to find out that we're not robots and we're not computers, but we're just men and women trying to solve human and citizen problems that come before us. So today, as you know from the topic from Kevin, the topic is going to be what you always wanted to know about judges, but always were afraid to ask. So here I am. I don't have any marshals, I don't have any robes, all right? I have no defenses. So now I'm going to let you fire ahead, shoot out any questions that you want me, and I will answer them. Yes, sir.
How can you stand in the case when you have strong personal feelings about it?
Okay, good question. If you have very strong personal interest or feelings, you shouldn't sit on the case. And I have recused myself in certain cases, and every judge has, okay? I'm experienced enough now to know in 28 years that there's like a situation in front of me, and the red flag and the alarm goes off and says, ooh, I've got to deal with that. I've got to go back down, I've got to deflate that, and I have to be able to be objective and reasonable with common sense and all the other good qualities you want in any decision maker, business or not, okay? So that's what I try to do, and I think most of my colleagues do too. I'm going to give you your case, all right? Now, I'm going to give you these facts, and then I want you to sentence this person. Okay? The victim is a 17-year-old beautiful girl, high school senior, on the way to college. She's killed by a drunk driver. This case is real, and it was in front of me. The day of the sentencing, the mother comes out and reads a letter to me about how she loved his daughter, all the things they did together, their Christmases and so forth and so on. Her head started to shake so much that the victim's advocate had to finish reading it. They had a blackboard there filled with all pictures of the child from birth to 17, all the happy events, right? Then her sister got up and spoke about their plans, what they wanted to do, what they were going to do when they grew up, when they had kids and their families, and when they, all these other wonderful thoughts. And then finally, they showed me a video of the trial, a compilation of videos from her infanthood right up until the time she died. At the very end, they had a picture of her with like clouds coming up as she was rising to heaven. The maximum sentence could be 10 years. What would you do? Now, let me give you a couple of twists on that. You don't know who the defendant is, right? We have to look at the total picture of the sentence. What if the defendant was 18 years old, which he was? And what if he was the boyfriend of the 17-year-old? And here's the one that I love to throw at citizens. What if the 18-year-old was your son? You think judging is easy? It's the toughest job that I can think of. These are the things we struggle with. They're the realities. If you go to my courthouse, there's a portrait there of Mom. Okay? Guess what I'm doing? I'm smiling. We finally found a portrait artist who can do teeth. I'm smiling. And I'm not holding a law book, I'm holding a book about children. And behind me, I'm the only one that has the American flag. And that's what we're all about today. Thank you, attorneys.
Conversation. I kind of think that I want to address one of the things on your syllabus, which was the case of McDonald versus the city of Chicago. Here it is. 134 pages times 2. Get them to be able to say what they said, whatever it was. Now, Attorney Baird, in her directions in the syllabus, referred to, directed your attention to the opinions of Justice Alito, Justice Scalia, and Justice Thomas regarding the Constitution and the Second Amendment to it to keep and bear arms. Of course, there are 4 other Supreme Court justices in that very case who disagreed with those 3. This is no surprise. The usual U.S. Supreme Court decision is usually 5-4 of the 9. And they are 100% predictable. Okay? The only one is Justice Kennedy, who's not predictable. As it was in McDonald's, there's something you should know again about this U.S. Supreme Court of ours. It is as political and as personal and philosophical things as can be. And it has been for at least the last 2 or 3 decades. This means, again, that most of their decisions are totally predictable. A few reality checks with you. I've met and dined with 4 of those U.S. Supreme Court justices, including Scalia and Thomas. And they're fun guys to be with. They're decently valued men. When you ask them a basic question, they retreat to the 19th century to answer it, rather than the 21st century's logic and reality. Let me expand on that. 7 of our 9 Supreme Court justices were law professors. It's been my experience, frankly, that law professors make the worst judges. Okay? They seem to be narrow-minded. They've come from one course that they've taught for 20, 30 years, right? They follow the letter of law, but not the entire alphabet of the law, which is the total citizen problems. Only one of them grew up poor. In my view, they live in another world, at times on another planet. Every one of them came through the federal system, court system. None through states. And for every federal case, there's at least 5,000 to 10,000 state cases that come through. We deal more directly with people and human problems than they ever think of doing. Okay? They do not see the reality, the horror, and the sadness that I, Attorney Baird, see almost daily in our courthouses. And no, I don't think you're probably going to hear any of them either from other speakers. Before I leave the McDonald case, I'd like to give you a quote from one of our 4 dissenting judges in that McDonald case. And here's what he said, and I'm going to speak loudly when I think the words are very important. He's talking and you know what he's about. How do these considerations apply here? For one thing, I would apply them only to the private self-defense right directly at all. After all, the amendments militia-related proposed to primarily to protect individuals from militia-related regulation. Moreover, the Civil War amendments, the electoral process, the courts, and numerous other institutions today help to safeguard the states and the people from any serious threat of federal tyranny. It's difficult to see how that right, as a majority in that case, Scalia and so on agreed, has largely failed as a popular concern and could possibly be so fundamental that it would be warrant incorporation into what the hell was the Heller case. And finally he says, or second finally, he says, in my view, this is the historical equivalent of claiming that water runs uphill. He then says, it is unlikely that definitive evidence, or what you're doing and we're doing here tomorrow, will develop one way or the other. And the appropriate level of firearm regulation has thus been, and continues to be, a highly contested matter of political debate. Okay. So that's where we are with that time call. Now on to part two. This is where I say good afternoon. I'm the cleanup batter this afternoon. Last speaker, so now you can go and relax after you see me, right? You've heard and will have heard during the course of this course from different professions and organizations and their lawyers. You probably noticed and will notice that some, if not all of them, display a very sharply vitriolic or emotional defense of their respective sides, although I understand there are no speakers here for gun regulation. Which is why I think doing it this way is, I think, wisely part of Attorney Baird to do it on this format, so we end up not having a facsimile of the Worldwide Wrestling Federation antics between the people who are opposed to each other. So as a judge for 30 years and a live person for 75, nothing in America surprises me anymore, okay? On this issue, with many others, I found that people with ingrained positions in their brains never change. Those with open minds do. They are in America, or a minority in America usually, but that's how America became America. An old politician friend of mine once told me, he said, here's how politicians operate when they run for office. They figure that 25% of the population is going to be for them, whether they're right or wrong. Another 25% is going to be for them, whether against them, whether they're right or wrong. 25% don't care. So all you have to focus in on the last 25%, and get 13 against 12. Okay? That's pretty much what's happening now in the world of right to bear arms. The signer of the Declaration of Independence lived across from my home in Litchfield. I'll overlook it. 2 doors down from my home is the first law school in America, Tappan Reed Law School. It was founded before our revolution and continued on past the creation of the U.S. Constitution. Now, let me tell you a little bit about our U.S. Constitution. It was drafted, written and drafted by 55 wealthy white men. It had at least 3 genetic defects in it. One, it excluded all African Americans, excluded all women, and still excludes all children. All 3 were essentially considered property. In fact, 17 of those 55 men owned 1,400 slaves. The African Americans were not citizens, period. Women could not own property or vote, nor could they become educated in any area except maybe the arts, household manners, sewing, and being subservient to their husbands. And children, in the recent Dred Scott decision, said they were not citizens either, but would succeed to the rights of their parents. So the young boys succeed to the rights their parents had, their fathers had, and the girls to their rightless mothers. That was the law in the infamous Dred Scott decision. Recently, I gave a speech down in St. Louis, Missouri, and I actually went in and sat on the bench where the judge made that decision. It's kind of eerie. Okay? But remember, historically, when people quote the Constitution to you, it's over 2 centuries old. A few things have happened. They didn't do texting in 1791, right? Our former enemy, England, is now our ally, right? We're not worried about them attacking us with redcoats. We now have no foreign or domestic threats to our individual freedoms. So what happened after that to bring us to this national constitutional divide on this issue? Beats me. First, I'm going to say I'm speaking on my own behalf, and not in any way on behalf of the judicial branch. Now, both sides of this argument become very passionate on this issue. That is why I'm a liberal on some issues and a conservative on other issues. That's why I'm going to be an intellectual 25%. Okay, who still uses their brain? I have in a long life learned that once a person's brain becomes so obsessed with that certain philosophy that they are unable to see reality. I can see in my colleagues in the court, some of the people there, I can tell them something, when it's conservative, I tell them something that's obviously contradictory to their belief, but somehow they assimilate it and put it into their brain and translate it, it comes out, well, that's on my side. Same thing with liberals. The automatic interpretation comes out of the lack of consistency with reality, with their reality, but not necessarily real reality. There's so many horrible things going on in the world, mass murders, child abuse and domestic abuse. You might think we might have other issues to fight about. Let me address this issue from my personal and professional perspective. Having sat as a judge on scores of cases with grieving families who lived the horror of their loved ones being killed with guns, some legal, some illegal. I've sentenced over 2,000 people in prison. I worked in a prison 3 years. I also deal with the sobbing families and the killer's families, all awaiting my judgment, just like Bill. I have deep concerns about our nation's powerful dedication to what I consider actually mini weapons of mass destruction. Too many of our children and their innocence are destroyed by our adult thoughtlessness. Now, I'm no stranger to firearms. I'm a U.S. Army veteran. My dad designed rifles for the U.S. Army, Marine Corps. He designed the M14 rifle. He also was the co-discoverer of the science of ballistics, as many people know, including Mr. Baird. When I was a child, he used to take me trap shooting, skeet shooting, and I learned gun safety. I fired pistols, rifles, machine guns. I throw hand grenades, and I've had a dead soldier shot in the head in my arms. And a judge, I've sat on many, many cases by firearms and tragedies. One guy I had, his brother shot his wife, killed his wife in the courthouse, and then shot his lawyer, favorite lawyer, and then killed himself, which is the accuracy of it. And when I did a search warrant for his brother's house, they found 37 weapons there, and someone gave us some more information back out on 46 more. Who needs all these weapons in their house? Sadly, you should know, it's a fact, that America, ours, is the world leader in the killing of its citizens by guns. For non-political reasons, isn't it time we took "it's not our problem" blinders off and confront reality? Each year we kill, by guns, the entire population of the city of Torrington, of 30,000 people. So let's do an historical check, a reality check, to see where the right to bear arms comes from. Everyone says the Second Amendment. Well, maybe. The Second Amendment says, a well-regulated militia, citizen soldiers, being necessary to the security of a free state, the right of people to keep and bear arms shall not be infringed. We have to read the whole part. It doesn't just say, the right of people to keep and bear arms shall not be infringed. It starts off by saying, a well-regulated militia, citizen, being necessary to the security of a free state. That's in the same sentence. Why would we only look at the second part? This amendment exists only because of our forebears' fear of a tyrannical insurrection or foreign invasion. So the real source of the Second Amendment is found in the real Constitution, Article 1, Section 8. It concerns the power of Congress to raise a standing army and its power over the militia. Now, I'm going to read right to the Constitution. Okay? It's very small. To provide for calling forth the militia to execute the laws of the Union, suppress insurrection, and repel invasions. The next part. To provide for organizing, arming, and disciplining the militia, and for governing such part of them as may be employed in the service of the United States. Reserving to the states respectively the appointment of the officers and the authority of training the militia according to the discipline prescribed by Congress. So, is that really the NRA's position today? Doesn't sound like it. Do they really and honestly feel we need a militia of them against the national abuse or insurrection or foreign invasion? Hey, In my view, those positions are antithetical and antiquated. The militia under our Constitution was under control of the states, not individuals or private organizations. The framers even pointed out that Congress had the authorization to limit the size and kind of militia and arms. They also said they were not to be lone rangers, but to be organized, trained, and led by trained leaders of the nation. The purpose, again, of the Second Amendment was to protect us from enemies, foreign and domestic. Times have changed. Hey, now we have 5 full-time and well-equipped separate national security forces, unlike 1991. We have the United States Army, United States Navy with its wonderful SEALs, whom I know, United States Marine Corps, United States Air Force, United States Coast Guard, okay? And add to that 50 separate state National Guards and thousands of police departments, not to mention Homeland Security. So the question is, why then do we need our citizens, hunters and sportsmen and target shooters armed with these powerful weapons of war to hit bullseyes, clay pigeons, and deer? When the framers thoughtfully examined these issues centuries ago, could they possibly have foreseen the AR-40-15s in the hands of virtually everyone? The constitutional originalism espoused even by our Supreme Court justices, including Scalia, misses the issue. If the Constitution is only to be looked at as of the date of its adoption in 1791, of course the amendments were not adopted by Connecticut until I think I was 3 years old. Okay, whatever reason. But if we look at only the date when it was found, when it was established, could those forefathers, and they were forefathers, don't forget, ever foreseen the handheld weapons that we have today? Because at that time, all they had were muskets and swords. And they would be appalled, wouldn't they, at Newtown? Wouldn't they be appalled at Washington Navy Yard? In their wishy-washy way, Congress provided a law that allowed the Navy Yard killer to go to Virginia and show a Washington D license plate and without any background check buy that shotgun. The law would prevent him from buying pistols, but not a shotgun. Now, I'm afraid that the bottom line here is not a happy one. I'm afraid the battle has been lost because of those under the guise of patriotism are ignoring history or contemporary 21st realities. I think they sometimes see their personal beliefs and realities as distorting the actuality. If we'd started this, or they had started this, 50 years ago, it might have made more sense because there were no such weapons. The best weapon was an M1 that guy had in the Army. So what can we do? Actually, we can do very little. Our infatuation with the past has presently impaired our sadly mind-boggling weapons. Every criminal or mentally ill person can obtain as many as they want. And if you want to know how to do that, let's get to that in a moment. Many are stolen from burglaries, from people who are innocent but have weapons there to protect themselves. And those weapons are used on another family to create more horror. Of course, everyone on that side of the RA can produce certain questions and examples that support and give you some. But when it's final analysis, they balance out. So finally, my message to you is that there is no answer, and there is no hope. And I don't care what legislators do. This problem has been so large, even if we stop made all guns illegal today, there's so many out there we can never enforce them. So we've lost the battle on that. And so we should just give it up. Sad add to history, for American history. But we're the only country that has this dilemma. Why? We self-created, we self-generated, and regenerated. Without missing the point of our forefathers and missing the point of human reality that I see every day. So, that's the end of my sermon.
Can I just expound on one thing you said,
Sure.
Judge Gill?
Sure.
Judge Gill mentioned that in the Heller case, District of Columbia versus Heller, I wasn't, or maybe you mentioned McDonald versus City of
I did,
Chicago.
yeah.
Right, that the decision was 5-4. How many people understand what that means? It's really, for those of you who don't,
Yeah,
it's a really important point, because, right, on the United States Supreme Court, we have 9 justices, and a majority, you know, without going into a lot of detail, but basically the majority wins when an issue comes before them. And to show how controversial this issue is and what a close call it is in our country, the case, Heller, that decided that the Second Amendment applies to individuals was a 5-4 decision. 5 justices basically said it was, it applies to individuals, and 4 said it didn't. How close did we come to going the other way? We came very close. And I had told you that I didn't get involved in firearms issues until 2007. Heller came along in 2008. How different would my practice be if it had just gone the other way? I wouldn't have a firearms practice. It wouldn't be relevant. The fight in that terms would have been over. The decision in Heller, which was only by 1 justice, really changed the game in the United States. And I don't think they're going to go back on that anytime in the future.
And what Justice McDonald, that was 5.
A good point. In McDonald, the case that applied the individual rights to people in the states, 5-4 again, could have been completely changed. And that's one thing I was discussing earlier when a representative from the NRA was here. They definitely strategize the cases throughout the United States. They've been working on this for 40 or 50 years, and I don't mean that in a bad way. But they've been working on it since the 60s, trying to get a case up to the Supreme Court to make that decision, trying to hold it back when they knew there were justices on the court that wouldn't go their way. Strategize it so it would get there at the right time with the right number of justices to go in their favor, and they did it. They did it in 2008 and 2010. And so, yeah.
Your Honor, you, I
Are you in this
believe,
class?
no, I'm,
Why don't you give it in writing?
excuse me?
Exactly.
You've got the gavel.
That's a first. Thank you, Your Honor. Any questions from students?
Sure, I mean, anything you want to ask about judging or law or this subject, I don't care, I don't.
Well, one question I have, I'm not, why am I?
You're not in the class either.
So you're running the class, so you got to stand.
Right, and I, no,
Would
again,
anyone yield their time?
again,
Who wants to go to jail?
I'll be back.
Time denied.
no comments from Mr. Peruta or Mr. Burgess or Mr. Cook in response to this question, okay? I wanted to ask you, you had started off saying that a judge, if their feelings are too strong about a particular issue, then they need to not address that issue. And then you gave such a well-prepared and articulate presentation to the class about an interpretation of the Second Amendment and a position that we hadn't heard yet today, so we're very grateful. Does your interpretation of that affect in any way your ability to sit on the bench and with regard to firearms issues, or you're able to set that aside?
No, I've
Right.
had, that one doesn't make my blood rise, or after.
Good, yeah, okay, I
So
understand.
I've had, I love one of the Hughes cases, not that any of these cases are huge, but here's how things can go awry. When the legislature tries to get involved in these cases, and they set what they call mandatory minimum sentences. So that takes away my power to sentence. Let me give you the facts of the case. And there was this 58-year-old man, and he worked for O&G Construction, and he worked there for about 35 years. He was a foreman. And his house was burglarized. So he called the police in. The police came in, they're sitting down in his living room, getting the facts and putting his name, his birth date, and the trooper checks him out, finds out that when he was 18, he was convicted of a felony for stealing a car. 40 years later, right? 40 years later, he's a grandfather. You know, he's a dad. He's a wonderful guy, great citizen. He was there to complain about somebody burglarizing his house, but the cop notices over his fireplace a shotgun. Is that yours? He said, yeah. He said, well, You don't have a, you know, you're a convicted felon, you can't have one. He said, your state's been licensing me for 20 years. So they arrested this man. He comes in front of me. He pleads out. I've got to give a 5-year minimum sentence to this guy. So in there is his boss, his mom, G, his wife, his children, even some of his grandchildren are there, right? And I said to the prosecutor, I said, you know, and to the audience, I said, I'm sorry. I don't think this is fair or just, but I took an oath to uphold the law, so I will do it. But it grieves me as a human being that I have to send this man 5 years to serve in prison with real criminals. This guy isn't even a criminal, okay? Just then, out of the clear blue sky, the nice prosecutor, state's attorney, says, can we have a short recess? I said, sure. I went to my chambers. About 5 minutes later, the phone rings. There's a mysterious voice on there. I don't recognize it. It says, Judge, look at statute 22222. Look it up and see what it says. It actually says a minimum of 5 years and or $5,000 fine. Or I go back in there. They're ready to put the cuffs on the guy earlier. I said, the court sentences you to a fine of $5,000. What? And out he went. So it did justice. And the legislature took the word out, or. So the next person will get the 5 years. So that's the question. Yeah.
I got a question on that. If the state granted him the right to carry a gun,
Yeah, they didn't speak to each other.
that's what I'm saying. Instead, like, if you go and fill out for a gun, and they gave you permission for the gun, the state allowed it, wouldn't it be the state's fault, not his, to even pay a fine?
Yeah. Well,
Right?
yeah, well, somebody made a mistake along the line, but technically he still committed the crime. So, and that's what was getting, that happens every once in a while, with other judges too. Get stuck in that trap.
Well, and that's an excellent point of view, because sometimes you'll hear that, oh, the firearms laws aren't enforced, or they dropped, the prosecutor didn't pursue the case, or the judge gave a light sentence. But they say that, and they don't know the facts behind it.
Right.
And so that statistic, when they say, oh, they dropped too many cases or don't treat them seriously enough, without knowing the facts like the judge does, it just doesn't mean anything. And it's more meant to stir up emotion than to actually make a informed decision.
And once you know, you're not going to really get the whole picture of newspapers or any place at all. That's the bad thing. Recently, I had a touch-the-gun case, and it was the dad and his son were out hunting on a Saturday, which was perfectly all right. And they shot one deer, and they shot another one, but it went away. So on Sunday, they went out there with a 22 going on, and they found the other deer, and it was flopping in the stream. So now, stupidly, the son videotapes all of this.
Oh.
So my father slashes the deer's neck. It's still going. And they're making jokes about it. And then Friday they shoot it with the 22. So what do they call the officers? The DEP come. They come and they give a ticket. It costs like $150 for shooting on Sunday or something like that, right? Well, they thought that was it. It wasn't it. Once that was on the internet, they got pressure from Hartford to go back. Now they go back and they arrest the guy for 2 or 3 felonies and so forth and so on. And he's applied for AR, and all the judges are talking about it. That's elevated rehabilitation. He doesn't get convicted of a crime because anytime up here, anytime I've had an animal case in front of me, I see like people from 3 state agencies, 3 private agencies standing in front of me, showing me the pictures like a wedding album of the dead animal. Do that to a kid, there's nobody there, you know what I mean? But it's an interesting job.
The animal cases get a lot of
What? They're hunting on their own property.
Well, that's what I'm saying. There's certain days you can't hunt.
Yes, Sundays, I guess.
Yeah, I don't know if they changed
So he
that.
doesn't hunt it on Sunday, he got arrested, and then.
He shot the animal on Saturday, and in theory, he's probably going back to euthanizing certain suffering. Right?
Yeah.
But when they keep that on each other, pictures flashing in the throat, and one one is swinging a little deer like Bambi, all of a sudden,
They show on National Geographic other animals eating other animals.
Oh, sure.
And this is just like an actual piece of life, like we, cow, and all types of other, how do you think they got cut up?
I agree with you. My 7-year-old asked me that question. He says, Pop, he says, I don't know if it's right for us to be eating animals. I said, oh, that would be right. And I said, well, some animals eat other animals too. Cows eat oats, but horses eat oats, but wolves eat the cows, and So I said, we'll come back when you're in junior high school and I'll answer that. That's the judicial discretion.
Yeah, what would it be if, say, a motorist struck a deer and they're not near any residential area and they want to disperse a kill it
Oh, I see what you
on a
mean.
Sunday? And does
Yeah.
that- I mean,
I'm not so sure about that one.
I don't have either.
I'm not so sure. I mean, what you're supposed to do, I think, well, with some animals like moose and elk, you're supposed to call the authorities. So if you call, for example, I did see I ran over a cat coming home from work, and I stopped, I don't know what the hell to do. State trooper came along, boom. So I was off the hook. Not guilty. Yes.
I have two questions.
Sure.
First one, how do you become a judge?
Okay, let me answer that one first.
Yes.
Okay. To become a judge, you have to be a lawyer, which means you went to, after college, you went to 3 years of law school, passed the exam, and you get a member of the bar, and then practicing law. It used to be you had to be a lawyer at least 10 years when I came on. Now, if you're going to become, this is 39 states, unfortunately, elect their judges. Huh? Imagine you're in a courtroom in one of the 39 other states, and somebody's suing you, and the lawyer, the guy suing you, gave $10,000 to the judge's campaign, and your dumb lawyer gave $50 to his opponent. You think you're going to get justice there? If you don't, what are you going to think about this? The second thing, before I get into how we do it in Connecticut, you should know that we are the only state of 50 that has never had a judge convicted of a crime while in office. Okay? Which is something proud of. Okay, so if you want to become a judge, someone gives your name to the Judicial Selection Commission, which used to be called the merit selection, except the judges who were already on didn't like the thought that other judges coming on with merit, they didn't have merit, so they changed it to the Judicial Selection Commission. That's composed of 16 people, 8 from each political party, about half are lawyers and half are non-lawyers. So they give you an application. The application is as big as the Torrington phone book. Okay? In there, you answer all these questions, you give the 10 most important cases you dealt with, the names of 3 lawyers or judges to recommend you, 3 or 4 citizens to recommend you. You sign away, you're released of all your financial records, all your marital records, all your tax records, all your health records, okay? Then after that, they call you in for an interview before this commission. Now, everybody knows, will ask somebody who knows you not to get the dirt on you, right? So you come in there, and you can always expect some tough questions. After that, they have to vote by a majority of those present, plus 2, to approve your qualifications, okay? Now, if that's done, then it becomes an opening in the Superior Court. We just have one court in the Superior Court. New York and Switzerland has 14 levels of courts. Can you imagine administering that? Some of their judges don't even have to be lawyers. And so after that, if there's an opening, the governor will let the commission know, and they'll send over 3 names to the governor, and the governor will pick one of them and nominate them. It's not over yet. Once you're nominated, you have to go to the Judiciary Committee of the House and Senate. They give you another telephone book, all stuff, and they do their checking background, okay? And then they have to vote, the committee has to vote by majority to say you're qualified. Then you have to go before the entire legislature, Senate, okay, and House. And then if that's all done, you could be sworn in. And you have to do that every 8 years. So I've done it 4 times. And of course, during the course of any 8 years or in 1 year, you could get somebody mad at you, and a lawyer mad at you. And they tend to show up and, do all that stuff. So I've always came through clearly. So that's how judges are chosen in Connecticut. I think it's a very wise system. No system is perfect. Okay, so sometimes we do have some slip through, or maybe we should have been doing something else. But I think, and usually they fade and just leave after they realize it. You know, because you really don't know the job until you get on the job. Okay, what's your second question?
What part of the Connecticut Constitution talks about militias?
I'll tell you the truth, I seldom look at the Connecticut Constitution.
It's up on the wall.
It's right over here.
Oh, yeah. Of course, yeah, that's, our Constitution was adopted, I don't know when, before or after the federal Constitution, I'm not sure.
I think what the student,
last amended.
excuse me, I think what the student is getting at is, in Connecticut, a lot of people view as the right to bear arms as a state right. In other words, we don't even have to rely on the federal constitution
Yeah.
in Connecticut. So,
Most of that.
so that's an argument.
That's
It
in
was-
most state constitutions.
Yeah.
No, it's not.
Yeah. Well, it's in
What
some.
states aren't they in?
I don't believe California, there are certain states that don't have the right
Do you know one
to
of the 50? Back in.
I get my class tomorrow, Your Honor.
All right.
Your Honor,
Let's get back to the student.
the Connecticut State Constitution was last amended in 1984, and Article 1, Section 15 has remained unchanged since the beginning. So it's not an antique right. It's current as of 1984.
Okay.
There's not a lot of Connecticut case law on that. I haven't seen any. I mean, there's some, but there's not a whole lot on it. It hasn't been, oh, it's 20 after. Yeah, it hasn't been,
I
it
went
hasn't been
overtime.
litigated much.
I went for the check. Any other last questions? Last chance at me.
So you're living good, pretty much.
Where did that come
I'll tell
in?
you what, my children are living much better than I am.
Isn't that what we strive for, though?
I want them.
Yeah.
They want them. My son's the chief medical.
I was going to bring that up, but I wanted to be sure. His
He was the
son
deputy in New York
was just
City.
elected chief medical examiner. What
I
is
like the point, yeah.
Oh, what does a chief medical examiner
He's
do?
in charge of all unexplained deaths in the state of
It's
Connecticut.
a big
He
job.
was
Yeah.
deputy in New York City, he did 800 body bags at 9/11. Okay, he testifies all over the world.
Yeah.
So that's one of my failures. And he's married to, I sent him over to Ireland to do his roots. He met a lady from Italy, who's a doctor, they're married. They're over here, and she's the director of pediatric pathology at Gill. My older son is the chief counsel and senior vice president of United Technologies, which means he's over the president of the elevator company, Otis, the helicopter place, and all the engines, Pratt & Whitney, okay? Number two, he meets with presidents of other countries, for God's sake. That's his own private plane, helicopter. He married a woman from Australia, who we met in Singapore.
Hey, are any of them giving you
Why
an
don't you stay
allowance?
close to home? Is it-
Brad,
And,
are any of them giving you an allowance now?
you know, would you sign my petition? Well, I got 3 names on it.
I want to know the 4 Supreme Court justices you've met. That's what I want.
Okay, and my daughter, the baby, is just started practicing law after being a lawyer for 10 years. She raised 3 children. Okay, well,
But you
Okay.
met 4 Supreme Court justices.
oh, God, yeah, I met, yeah, I correspond with 2 others. I correspond with Senator Day O'Connor and with Sonia Sotomayor. She wrote a book to me, it was excellent. And I've been working with them on some projects. But and years ago, when I had lunch with Thomas, okay, in the lake, he was very nice. He got to speak, and he says, "All right, let's talk. Any of you know anything about what's that case? Kuchima's, the one about Korematsu. Remember that one?
Oh, I do. But, yeah,
It
that's.
jumps up. Does anybody know anything about Korematsu? So it was right opposite. So I said, yeah, that was the case where the Supreme Court allowed us to take Japanese people and intern them during the war. And next to him are 2 deans of Yale law, of 2 law schools, to say the names. And they say, yeah, Justice Jackson wrote the opinion. I said, actually, it wasn't. I said, it was about, excuse me, but, well, I can't argue with the Supreme Court justice. But when I got back home, I took out the opinion, where the last two paragraphs were Justice Hugo Black, not Jackson. The other teacher saying Justice Jackson. He wrote the dissent, Justice Jackson. These are law school deans. So naturally, I let them all alone. He was right one. But he was a very nice guy. Scalia I had dinner with in Washington, D.C., Catholic Hill. And actually, I put two questions to him that he totally fucked up. One was, I said, why can't we put children in our Constitution? He said, that's a states' rights issue.
Now, he has 9 children, I think.
Yeah. He's a
A
very
Supreme
Catholic
Court justice has
justice.
9 children,
Oh,
right?
yeah. And then he fluffed that up. But then I asked him, I said, on your original stuff, like I did with the muskets, kind of took that little turn. He just had our picture taken together. Oh, he wouldn't have taken it afterwards, I'm sure. So those two. And then you go back and spend the whole afternoon with him. When I was in law school, I went to Lord. And my pleasure was to be with him. And I asked him about firearms. And I addressed him afterwards.
Thanks.
He was a nice guy. And all in Ginsburg.
Oh,
We both gave speeches up at the International Judges Association in Denver.
I enjoyed it.
She's very talented with that.
Well, Charlie Beta was in my evidence class last semester, and we actually listened to some Supreme Court arguments because we listen to them on the internet. And when she talks, her voice is very distinct. You definitely know it's her talking or argument. Yes, everybody recognized her voice. Yeah.
Yeah, that's very true. She is monotone, but she's friendly, I guess. And when do you think the first lady was on the Supreme Court? What Supreme Court?
I think I know. Candidate O'Connor.
Right, 1981.
Right?
Until that time, we never had a woman on the U.S. Supreme Court.
And how many do we have now? 4, right?
You got Elena, Ginsburg, and Sonia.
There's not a
3.
Only 3. Okay, 3.
Okay, so who's going to take me out for a beer?